the 4th, 5th District of the State of Florida is now in session. The Honorable Harvey L. J. Chief Judge presiding. All persons have business before the court draw near. Give attention, you will be heard. God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal. We have two oral arguments this morning, and I am Harvey J., as you just heard from our marshal. I'll be presiding for both cases this morning. To my right, Judge Edwards, the immediately past Chief Judge of our court, and to my left, Judge John Harris, longtime Chief Judge of the 18th Circuit. These two esteemed colleagues are obviously an important part of this court. Remember, this is a courtroom, and what goes along with it being a courtroom. So if you would be kind enough to make sure your cell phones don't go off in the midst of that, of the OAs today, that would be appreciated. If the advocates would be careful to listen to our questions, please try not to talk while we're speaking. As you all know, part of why you're here is to answer our questions. And so if you do not do that, that defeats one of the purposes we have you here for. The last thing, we will not take a break between cases, but we will give counsel an opportunity to leave the courtroom. If there are spectators here, not a big crowd, but if you would be kind enough maybe before the next case to leave, if you're here for the first case. The reason I say that, it's disruptive to have people leave the courtroom in the midst of argument. That's not good for the court, it's not good for the advocates. So if you are here for the first case and would like to leave after that first case, it would be appreciated if you would leave at the short break where we transition the new lawyers in, and then we can get started with case number 2. But the first case this morning is Cruz, case number 2025-0232, and on behalf of the appellant, Ms. Baden, would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes.
All right, so noted for the record. Please proceed.
Good morning, Your Honors, Chief Judge. May it please the court. My name is Rachel Batten, and I am the attorney for the appellant, Michael Cruz. Mr. Cruz comes before this court to respectfully ask for a reversal of the trial court's order involuntarily dismissing his petition for guardian advocacy based on a lack of case jurisdiction. We request that relief based on 3 separate points. First, equity. Second, inapplicability. And third, the law and public policy. Just a brief factual background for the court. James Vincent Cruz, who I'll refer to as Vinny, is the adult autistic son in common between Mr. Cruz, the appellant, and Helen Waischke, the appellee. They both initially petitioned for a plenary guardianship over Vinny, seeking appointment as his guardian.
This case is all about case jurisdiction.
Yes, Your Honor.
Can you differentiate case jurisdiction from subject matter jurisdiction?
Your Honor, I certainly can, but I think the Florida Supreme Court did that for me. We did file.
And I read the opinion. I'm sure my colleagues did too. You're talking about the Schmidt case, the Labarga opinion that just came out over the summer.
Yes, sir.
So as I understand, subject matter jurisdiction is something that can always be raised with the parties, whether the court has the power to adjudicate a matter. But within that band of power, there are cases, case jurisdiction, whether the court has jurisdiction over a particular case, even though they will have, the court has subject matter jurisdiction over the whole swath of cases, but the particular case is whether or not the court has case jurisdiction. Is that a fair synopsis of what we're speaking of?
Yes, Your Honor, and I think the very crux of the difference, which is important in this case, is subject matter jurisdiction is not waivable because it deals with the court's power to adjudicate a particular issue. The Florida Supreme Court in JJJ TB versus Schmidt said case jurisdiction is waivable. And a party failing to timely raise an objection to case jurisdiction in the trial court has therefore waived that objection. In this particular case, the record contains no reference to case jurisdiction, no motion to strike, no writ of prohibition, no motion to dismiss for lack of case jurisdiction. It was not even addressed at the motion to dismiss hearing, which dealt specifically with personal jurisdiction. Instead, it was raised by the trial court in its final order issue.
Is that not a distinction without a difference? I mean, the jurisdiction was raised. I know not the term case jurisdiction, but jurisdiction was raised. That's why we're here. Had it not been raised, there wouldn't be an adjudication on that, would it not?
Your Honor, personal jurisdiction, also subject to waiver, and subject matter jurisdiction are distinct in this particular case.
I understand, and I think we all agree. There's subject matter jurisdiction, there's case jurisdiction, and there's personal jurisdiction. All different, all multi-variegated in their definitions. But jurisdiction was brought to the court's attention here.
Only personal jurisdiction, and we were never heard on the issue of case jurisdiction. And in the, I'm going to refer to it as the Schmidt case, Your Honor, if you don't mind, because there's a lot of letters.
Yeah, I refer to it to avoid the acronym.
And in the Schmidt case, the Supreme Court specifically pointed to a public policy reason for its basis to find that case jurisdiction was waivable. And that is essentially when a party knows there's not case jurisdiction and does not bring that to the court's attention, therefore leveraging the litigation. In this particular case, Ms. Weischke, after Mr. Cruz filed his petition for guardian advocacy, sought documents, the request for production, sought interrogatories, took and set his deposition. Vinny's attorney sought court-ordered mediation. Mediation was held, and litigation went on for 2 years, just like in that Schmidt case. And the court said that setting a precedent where we would allow parties to conceal these errors of case jurisdiction, leverage the litigation, and then get an adverse outcome, only to then, for the first time, raise the issue of case jurisdiction on appeal, would set a bad precedent and would allow litigants to essentially leverage jurisdiction as a weapon.
And I obviously saw that in Schmidt, read Schmidt, but that was an appellate gotcha case, was it not? Did we have an appellate gotcha here? I mean, jurisdiction was raised. I know it wasn't case jurisdiction, it was personal jurisdiction. Jurisdiction was raised. That was the reason the court dismissed the case, was case jurisdiction, was it not?
Jurisdiction was raised, Your Honor, but I think, again, the Schmidt case makes it very clear that personal jurisdiction, subject matters jurisdiction, and case jurisdiction are wholly distinct.
Why did the trial court dismiss this case?
The trial court dismissed this case for lack of case jurisdiction.
So there you go. Was there a motion for rehearing filed to that saying that it was waived?
No, Your Honor, there was not a motion for rehearing.
Is that not a waiver of the waiver?
So, Your Honor, 2 points regarding the motion for rehearing.
Yeah.
So, first, the motion for rehearing is not found, interestingly, in the Florida probate rules. There's only a vague reference to it regarding a time frame. So, unlike other areas of law, there isn't a robust structure set out in the Florida probate rules for rehearing. Secondly, this particular issue raises a fundamental error.
And I appreciate that. I appreciate the unique situation where we haven't adopted all the rules of procedure into the probate rules. But so there was no motion for rehearing, no motion for reconsideration?
No, Your Honor, there was not.
Was there anything to bring the court's attention to the fact that the position of your client was that case jurisdiction had been waived?
Your Honor, at the time that the order was issued, Schmidt had not yet been promulgated by the Florida Supreme Court. There was a split in the jurisdictions, the 4th District saying it could be waived, the 2nd District saying it could not be waived, and this court had not yet weighed in on the issue, so there was no controlling authority to bring to the court's attention regarding the waiver issue. We now have Schmidt, which says unequivocally that failure to raise the issue is a reversible error, or failure to raise the issue, it causes reversal on appeal. And
Counsel, can I interrupt you for a second? Even if you lose on the waiver issue, do you think that's it, you're done, or do you think the judge got it wrong?
No, Your Honor. So the waiver issue dealt with my first point of equity. There are two alternative arguments to be made for
Let me
reversal.
ask you some timing issues, if I could, and if you need to look at them while you sit down waiting on your rebuttal time. Here, the joint petition was filed to have him declared incapacitated August of 2022, correct?
I believe so, Your Honor.
All right, and then Mr. Cruz filed two things in one e-filing. I looked to see if you could even see a second difference between them, or if there was a difference on, I don't know exactly what the word is, but the code. You get a code almost like a receipt number. So these two pleadings were filed at exactly the same second according to e-file, and exactly the same receipt number. But on March 10, 2023, Mr. Cruz filed his motion for appointment as guardian advocate, and he also filed at the same second, by the magic of electronics, his notice of dismissal, his part of the joint petition, which said in the title and in the body, I'm dismissing my part of the joint petition and intend to file a guardian advocacy petition, which he did at the same second, correct?
Yes, Your Honor.
Then March 24 of 2023, Ms. Waschke files her motion for guardian advocacy, correct?
Yes, Your Honor.
Okay, so you've got all those motions are pending, for two motions pending to be appointed guardian advocate, correct?
Yes, Your Honor.
And it's in September of 2023, Ms. Waschke files her amended motion to dismiss regarding personal jurisdiction or perhaps venue. Wasn't that clear? And it's not until March of 2024, a year after Mr. Cruz files his papers, Ms. Waschke then dismisses her part of the joint petition, correct?
I believe that is correct, Your Honor.
Well, you can double check these. And then January of 2025, several, 9 months later, whatever it is, that's when the court finally dismisses the case. But when he dismisses the case for lack of case jurisdiction, there are pending two motions for appointment as guardian advocate, aren't there?
Yes, Your Honor. One filed by Mr. Cruz, and then I believe it was titled as a counter petition filed by Ms. Waschke approximately a week or two after Mr. Cruz's petition.
And both of those guardian advocate petitions were filed while Ms. Waschke's part of the joint petition was still pending because she didn't dismiss hers until March of 2024, a year later. And again, feel free to double check that, but assuming those are correct, and I can give you some guarantee on that, but there was a lot still going on in this case. This was not like a case where somebody goes in, dismisses their case, goes home, and everything's done. When Mr. Cruz withdrew his part of the petition, he immediately, at the same time, literally the same second, same filing, filed, here's this motion, I wanted to be appointed as a guardian advocate. And you can be appointed as guardian advocate without a declaration of total incapacity, can't you?
Yes, Your Honor.
So this was not a case where nothing was going on because the parties had dismissed everything and then they decided to start over, is it?
No, Your Honor, and that brings me to my second point about inapplicability related to the case relied on by the trial court to dismiss Mr. Cruz's guardian advocacy petition, which is the Kottke versus Birch case. In that particular case, there was that intent, that clear abandonment of litigation, that expression to withdraw all pending motions, all pending pleadings, all pending requests for discovery, saying, I am requesting no further relief from this court, I am done with my litigation. And then a person who had only become involved in the case after it was initiated tried to essentially piggyback off of that withdrawn petition and file their own petition for incapacity. So that particular case is essentially inapplicable to the facts that we have here because there was no intent by Mr. Cruz or even Ms. Waschke.
You like the Howard case better, don't you?
I don't know if I would say I like it better, Your Honor. It does exist. I do think that perhaps there might be a little bit more facts to help guide us in our analysis, but the facts and the opinion are what the facts are. And the court's recitation of the subject of the particular proceeding, I think, is applicable to our particular case and goes to my third point about the law and the public policy involved in these particular types of cases when we have guardianship or guardian advocacy related to incapacitated individuals.
When Howard, the mother, father, and brother jointly petitioned to take care of the daughter and sister because she was incapacitated. And they filed a petition for incapacity and also to be appointed as guardian advocates, didn't they?
Yes, Your Honor.
And although there were other issues in the case was not dismissed because of a lack of jurisdiction, was it?
No, Your Honor. So the case actually was not dismissed. The court did find incapacitation, which is under 744, and then also appointed a guardian advocate under 393. And it was reversed by the appellate court because the order did not comply with the specific statutory requirements under 393. That case can be read potentially for the idea that there can be a request for incapacitation that can result in the lesser restrictive alternative of guardian advocacy, which comports with the legislative intent that is replete in 744.
As we talk about cases, we've talked earlier about Schmidt, which was your, a notice of supplemental authority, and then we got a second notice of supplemental authority, Pino. How does Pino play into any of this?
Your Honor, I don't presume to know why the appellee may have filed Pino. Pino specifically discusses whether or not the court can set aside a plaintiff's voluntary dismissal based on a request from a defendant. When the defendant alleges, after litigation has ceased, based on that voluntary dismissal, that there was some type of a bad act or fraud on the court. I would have to defer to my opposing counsel as to why they filed that particular opinion. I apologize, Your Honor, I can't speculate.
Well, I read it again, and it's, well, better keep my mouth shut, but it's a long opinion, I'll put it that way. But it does, a lot of it's predicated upon the rule, which does not overtly apply to this case, correct?
Correct, Your Honor, and that brings up another point regarding the Kottke case. So in guardian actions, they are meant to be non-adversarial because the intent is to protect these vulnerable people. And there is a particular rule, a probate rule, which allows the court to either find a action as adversarial because of what's going on in it. There are some that are deemed adversarial by their very nature, and then the parties can declare it to be adversarial. And if it is triggered under that rule, then the Florida rules of civil procedure apply. But in this particular case, none of the parties declared it to be adversarial. The court, unlike in Kottke versus Birch, did not declare it to be adversarial, and the particular matter pending before the court did not meet any of the requirements of the rule to essentially be deemed per se adversarial. If there are no further questions, Your Honor, that is my time, and I would like to reserve the remainder for rebuttal.
Thank you.
Thank you, Your Honor.
Good morning.
Good morning, Your Honors. My name is Robert B. Asadi, and I represent the appellee, Helen Waskey. I don't represent the ward, James Vincent Cruz, called Vinny in this case. He was represented by another counsel who didn't file a brief in this record, but she relies on the report that she filed that the trial judge relied on in making her decision. Judge Edwards, I think it was you that said, you look at the top, look at the top of the petition. There was a joint petition filed in this case, pro se, by two people without representing. It's filed in the exact same thing as their notice of appearance where Ms. Batten represents Mr. Cruz. It's the pro se thing filed with her notice to represent the husband. And the wife, who thought this was former wife, they've been divorced for 20 years, thought this was going to be non-adversarial. And then it became adversarial when the father wanted to take custody of the son. Now bear in mind, this is not a child thing. He's 29 years old. The record shows he's 6'4", 220 pounds. He's not a child. And the mother has had custody and taken care of this young man for his entire life. The son has lived with the mother from the divorce when he was 9 until when his attorney took his, not deposition, but interviewed him 20 years later when he was 29.
And he still indicated he wanted to live with his mom, correct?
Absolutely. And made it,
Was my timeline correct from what you
your
just said?
timeline is correct, but I throw you to this is a little different, because you're talking about the motion to amend, done later. I'm talking about the very first filing in this record.
Well, let me ask you about that too, and follow up on what Judge Edwards was asking about the continuing jurisdiction.
Yeah.
At the outset, there was this joint petition for incapacity.
Correct.
And you're saying the court lost jurisdiction when that was voluntarily dismissed.
By him, yes.
At the same time, though, there was a joint petition for guardianship filed. That was never dismissed by anybody. That still was pending the whole time, right? There were 2 petitions filed from day one, 2 joint petitions. The incapacity petition was dismissed by Mr. Cruz first and by your client, a year later. But the other petition was never dismissed by anybody, was it? Or am I just reading the record wrong?
I hate to say this, I just don't remember. I mean, the point is, when you voluntarily dismiss your case,
Well, he dismissed 1 of 2.
but that's not a case. I mean, that's not a, what's the case that's there? I mean, if there's no,
Petition to appoint, or a petition for guardianship.
but I think that's what he moved to dismiss. I could be wrong.
Well, it's not.
It isn't.
He moved to dismiss his portion of the incapacity petition.
No, what was dismissed from my reading of the record, and again, you correct me, now's your time. They filed the joint petition for incapacity. Then, like I said, at the same second, same receipt, same everything else, Mr. Cruz, you can't tell which was first. Maybe he dismissed his part of the joint petition for incapacity and filed his petition for guardianship, and then 2 weeks later, Ms. Waschke filed her motion for guardian advocate appointment, and it's not until a year after that Ms. Waschke dismisses her part of the joint petition, March 14 of 2024. And to me, again, this is not a case where somebody dismisses their complaint and everybody quits. This is more in the line of an amendment. I'm no longer, as Mr. Cruz, seeking total incapacity. I'm seeking guardian advocacy, which is, the courts, the law is always look for the least restrictive means that still takes care of the needs of the incapacitated person. So it's almost like an amendment. I'm not seeking full incapacity. I'm going for guardianship. And then Ms. Waschke she doesn't dismiss her part yet. She goes, okay, well, if there's going to be a guardian, I want to be the guardian, which, again, is totally understandable for her to take that position. But you've got those 2 things in front of the court. Hey, we both want to be the guardian. Maybe we both can't be, but one or the other of us ought to be. That was before the trial court, and nobody ever moved, as appellant said in here, and by filing that case, nobody ever said, hey, wait a minute, there's no continuing jurisdiction here. And again, Ms. Waschke doesn't dismiss her petition, her part of the petition, until March of 2024, which is 2 years after it was filed and 9 months before the judge issues an order. So there's a lot going on still in this case, not to mention the discovery. This is not a case where somebody dismissed their case and went home. They dismissed a part of a petition and immediately, you can't get more immediate than what the timing is on the court stamps here with the e-filing, immediately filed the motion to be appointed guardian. So this was not, I quit, I go home. But that's how the judge treated it. And again,
It's a long question.
What's that?
That's
It's a long question, sure.
I'll do my best to answer it if I
Okay.
can. Nobody mentioned the case of Katke versus Bershey, which is a case out of this court. And it says when a party, it's a writ of prohibition, and there was no writ of prohibition in this case, but it's very clear on this, and that's what the court relied on. The court said, look, this court said, if you dismiss your original petition, I have no jurisdiction to hear anything filed after that.
I understand that's what the case says, and it also says that the trial court must accept a dismissal.
Correct.
I'm not aware of that in any rule, really, are you?
Yeah, that's the case we filed as supplemental authority from the Florida Supreme Court, written by Justice Pariente, thank you.
When somebody dismisses their case, it's dismissed.
I don't...
Katschke says you have to have the judge accept a dismissal. Did the judge accept these dismissals?
No, actually, it doesn't say that. What it says is when you file a dismissal, as soon as that dismissal hits the mailbox, the case is over. That's what it says. When you dismiss
There's a big
case...
distinction that you're missing and that the trial judge, I think, respectfully missed, is there was no other pleadings pending at the time of the dismissal in Katschke. So once that was dismissed, there's nothing left. You can't come in later and file a petition. Here, there were other pending petitions.
I'm sorry, and I apologize because I wasn't ready for this, but there was a petition to appoint a guardian, a petition for appointment of a guardian.
Right.
Filed the same time as all of these petitions were filed. And when he moved to dismiss this, not the least of which is filed at the same time that his counsel filed her notice of appearance where she represented one party and not the other. So these were not joint petitions. He dismissed his petition. And, I mean, if we're wrong on that, that's fine. We can go back to our other two arguments, which I think the Katke case is binding in this
And if I could, counsel, the Katschke case says, once the trial court accepted the withdrawal of the petition, it lost jurisdiction of the case. Do you know of any rule that requires a trial court to accept or not accept a withdrawal?
No, I think
so
it's
it's
the
not- I mean-
opposite. They don't have to accept a withdrawal.
But that's what
Part of the
Katschke
problem
says.
is-
I don't know why it says that, but that's what it says.
All
So
right,
if you're
well,
relying
part
on
of-
Katschke,
If I can respond, part of the problem here is when we're talking about case jurisdiction, that it's waivable, that's when case jurisdiction is an affirmative defense. This is not an affirmative defense. This is the judge finding that Mr. Cruz dismissed his case and Mrs. Waysky dismissed her case, so she had no jurisdiction by the language that's in, I'll read from the case.
But what do you do again? I think the point that my colleagues are making, we've got a second petition here. I mean, how is this not akin in a civil case, my former life? And a plaintiff dismisses one claim, but keeps in place another
And
claim.
here-
I mean,
here's-
nobody would say, that's it. There's
Yeah,
no
here's the problem.
jurisdiction.
Here's the problem with that.
Let me respectfully finish. Thank you for letting me finish. But no one would say, that case is over. There's no case jurisdiction because there's a pending claim still in front of the court. And I think that's what Judge Harris and Judge Edwards are trying to understand, as am I. What about this other petition? Isn't that still alive at the time the court dismisses this? Or not?
I think the answer is no, but if I'm wrong, then you'll tell me I'm wrong. You know, they dismissed, you got to remember, this is not one plaintiff filing a claim against one defendant. This is two pro se plaintiffs filing multiple motions, both pro se. Both petitions were pro se, filed at the same time.
And a
that
petition
one
is a pleading, by
It's a
definition.
pleading by two different parties.
And by
Are you talking
definition.
about the petition to determine capacity?
Yes.
Petition to determine capacity is titled Petitioners Michael John Cruz and Helen Waschke do hereby file this petition seeking a determination of incapacity of the respondent and state as follows. They both did it.
Never filed, never signed by an attorney.
Well, so what? They filed it. You
Because
don't have
then
to have
now an attorney represents one party that both parties thought this was an uncontested petition, and it became not uncontested.
Okay, so that's fine. Then they each, through an attorney, they each separately filed a petition for guardianship, didn't they?
Yes.
Which was pending at the time, each petition was still pending
Yeah,
at the
but-
time the judge dismissed the case for lack of continuing jurisdiction.
Okay, I would say the answer is no, because he dismissed his petition, but if I'm wrong, I'm
What do you
wrong.
mean, when you say no, it's just the fact that they filed something And again, Ms. Waschke didn't dismiss her part of the petition for a year after they both put in their motions or petitions to be appointed guardian. I mean, a year later. And then they did
Part of
discovery.
the-
The case
and
was
it's hard
not,
to
I
do
mean,
the
you act like
timing
the
on
case
this
was,
case.
excuse me, counsel. You act like the case was over. Go ahead.
Part of the problem with going through the timing on this case is the 2 years is made up of plaintiff's attorney and other's attorney taking 6 months off for being in the hospital and other issues in this case. There's a 6-month gap between when the petition was filed and they were going to appoint 3 people to determine whether this person is incapacitated. 6 months later, when they finally get to it, one of the 3 people is not even in Florida. He can't interview this person. And by the way, he doesn't live in Florida. He lives in Arizona. And always lived in Arizona and still lives in Arizona, which is where his mother lives. And that's her address on the petition. That's her address.
That
on
doesn't
the-
support a lack of continuing case jurisdiction.
Is
So-
there anything in the record saying that these petitions for guardianship were dismissed? And by the parties?
There are 2 separate voluntarily, not involuntarily.
I'm not talking about the petition for incapacity, I'm talking about guardianship. Difference, right?
Yes.
So is there anything in this record saying that petition for guardianship or petitions for guardianship were dismissed by the parties?
If that's the decision of this court, then I'm wrong. I think it was dismissed when they moved for it, but if I'm wrong, I'm wrong. So what's the alternative? I mean, what's the result?
Well, and we're trying to understand. Please, we want to get this right. We're in the business of getting right answers. I mean, that's the purpose behind this. Is there something that where the party said, I think it's clear, the joint petition for incapacity evaporated, but the point of Judge Harris and Judge Edwards, now Judge Jay, is the guardianship petition is still alive, unless there's something out there saying it was dismissed by the parties.
Not 1, but 2, actually.
2 petitions.
Well, excuse me.
Let me ask, I'm sorry to interrupt, but just because I did so much of this in a previous life, there's a difference between a petition for guardianship and a petition for guardian advocacy. These independent, separate petitions that were filed by the parties were guardian advocacy, right?
Yes.
Okay, that's not guardianship.
No.
At the outset, though, day 1, there was a petition for guardianship. Joint
Pro se,
petition.
yes, that's
Joint
correct.
petition for guardianship. That's never been dismissed by anybody. Right? Well, actually, I should say, your client, when she did her voluntary dismissal, put in hers that she dismisses her portion of the incapacity petition and the guardianship petition. Mr. Cruz never did that. So his portion of the joint guardianship petition, not the guardian advocacy, but the guardianship, has always been pending. Does that sound right?
Well, it's certainly something that was never raised in the briefs, I'll say that. What you're arguing now was never discussed, never argued at all.
I'm not arguing, I'm asking.
Yeah, it makes perfect sense, and I understand you want to be right. And I'm trying to review the order that was issued by the trial court. And the trial court relied on the Bershke case. I've read it, reviewed it, said what was happening. Finally, I think after some various and sundry mediations and meetings and trying to resolve this case wasn't going to be resolved. So finally, Helen Waschke dismissed her case, thinking that the case was then over, because that's what she assumed was the case, and they had a case that the trial judge ruled on. And you're right, they didn't move for rehearing to address that case. It's a case out of this court that makes it clear when you dismiss it, the trial court has no jurisdiction to hear further petitions or anything else. Now, if you're saying that petition was pending, how does that coincide, or how did they pursue it? No. Did they seek a hearing on it? No. They did nothing. They filed a separate individual, and remember, this is two people not represented by an attorneys, filed a pro se thing, and on the exact same day, an attorney files a different thing, and then they file a motion for a different guardianship, relying on the exact two documents that supported the original petition. So this gentleman, this incapacitated person, there are two letters from his doctor attached to the petition for guardianship, and there's two attachments to the limited guardianship. And they both say the same thing. He's 30 now, he's going to be 30, next week 31 years old. He can't brush his teeth, he can't cook for himself, he can't live by himself. He needs to be taken care of. His mother has taken care of him for 20 years. He hasn't been in Florida for decades, which his attorney told the judge that. The judge knows that. It's in the record. It's in the Melanie Burpee's report to the court. It's in the record. Read it.
Well, I mean,
We have read it, counsel.
Your
How
client-
else do we know all these things?
I know. So
Your client put into the joint petition under penalties of perjury that,
yes,
that he lived in Florida.
yes. Well,
Well, that's what it says,
she lived in Florida when she signed that document, yes.
that the son lived in Florida. He was a resident of Florida. Now she's filing something that says he's never lived in Florida.
The father lived in Florida, and the record makes absolutely clear that there was liberal visitation over 20 years. This is not something that happened this time. They did this so he could get dental work. Why? Because he's 6'1", 220, and they had to sedate him, and they had it done at Shands. Now, did he live in Florida? Yes. He came to Florida, stayed with his mother, who has relatives here, stayed with his father. But since this whole started taking place, he hasn't been to Florida. He hasn't seen his father in however many years because of this. So if you want to send it back, fine, but he doesn't live in Florida now. And if you're saying, what, they served this incapacitated man who was appointed an attorney when it was an uncontested case. They didn't appoint an attorney to be his representative in a contested case. They asked for a new attorney to be appointed. Oh, well, he's already been appointed an attorney. Well, does that, I mean, I'm an attorney. You represent the person who appointed you. So he was appointed, Ms. Burpee, was appointed to be an uncontested, who wants to be the guardian of this child, both parents. And then within the exact same day, same filing, one attorney represents one party and not the other. They file a different, supposedly limited attachment with the same documents attached. So when you look at and I agree that the limited guardianship they're asked for does have lesser requirements, but they didn't identify those requirements at all in that petition. And the Fifth, this is the Fifth District, the Fifth Circuit, which is where this is, doesn't have a form for this kind of limited capacity. You can do the petition for guardianship, it's online. I see I'm out of time, so thank you. I appreciate it.
Thank you.
And I apologize if I interrupted you. I apologize.
Rebuttal?
Yes, Your Honors, thank you. Admittedly, 744 and the Florida probate rules aren't very clear, very helpful when we're dealing with a situation where we have a contested guardianship, like this particular case, or even a situation where it starts out as a plenary guardianship and the parties later determine that guardian advocacy may be a more appropriate alternative. And I believe, Your Honor, Judge Harris, you had stated, the definition of a guardianship. We also have a conflict there because the Florida probate rules under 5.015B6 refer to guardianship as a formal guardianship, a plenary guardianship, or a guardian advocacy. So unless a rule indicates otherwise or a statute indicates otherwise. Admittedly, there is also no rule regarding amendments. So in the event that Ms. Waischke and Mr. Cruz wanted to amend their petition, there's no rule governing how to do that amendment. Back in 2023, when both parties filed their petitions for guardian advocacy, Section 393.12, which tells us what needs to be in a guardian advocacy petition, was different than its current iteration. It was amended in 2024 to be closer to what we find in 744 regarding the petition for incapacity. So arguably now it may be a little bit easier to amend, but back then they had separate and distinct requirements meriting the filing of a new petition. And lastly, Your Honor, circling back to my third point regarding the law and public policy, I believe counsel referenced that this is a young man that needs to be taken care of, right? He can't brush his teeth, he can't care for himself. If something were to happen to his caregiver, he would be listless. He would not be able to carry out the tasks necessary to take care of himself. And that is why both parties came before the lower court seeking redress of that particular issue, seeking the authority, and also setting up a plan for this particular young man, for Vinny, so that in the event something were to happen, there was a plan in place and an individual could meet his particular needs. If there are no further questions, Your Honor. Thank you, Your Honor, Chief Judge.
Thank you. That concludes our first case of